70% of all mass shootings in schools are committed by those 18 or under. But the Fifth Circuit Court of Appeals and MAGA don't care about that. They are fine with teenagers owning guns under the Second Amendment. We have a new Fifth Circuit, where else? Fifth Circuit ruling penned by Judge Jones in a 3-0 decision that says that teenagers have a constitutional right to own a gun. The very same teenagers who have committed the majority of school shootings. I'm Michael Popok. You're on Legal AF. Let's get to the new Fifth Circuit decision by Judge Jones. It should come as no surprise that since the 2022 decision we call Bruen, coming out of New York, penned by Justice Alito, which said that there was an individual Second Amendment right to bear arms, and that the only way the government, the federal government or state government, could regulate gun ownership is if they found a analog or twin regulation from 1791. Okay? And if you couldn't find it there, then our history of gun ownership and use would allow people to own guns if there was no regulation in 1791. Putting aside for a moment the firepower that's now on the street, the automatic and semi-automatic and bump stock weapons that are out there, the proliferation of mass shootings and school shootings, church shootings, temple shootings, supermarket shootings, and the like. And the fact that, I'm not making this number up, 70% of mass shootings in schools are shooters 18 or under. Despite that, Edith Jones and the Fifth Circuit and MAGA think they should own guns. See, they lie to the American voter and the American people when they say they're about gun control. They're about making sure that children are not shot and killed while they're trying to get an education. They don't care about that. They have prioritized the Second Amendment effectively over all other rights in the Constitution. And they've done it like in a rank order, like Second Amendment, it beats all others, when we know that's not true. Let me give you an example of what's happened since 2022 and that Bruen decision. There have been over 1,600 court cases around America about how to apply Bruen. Is the regulation that the state or local or municipality has, does it fit within the 1791 framework or not? And it's been split. About 800 courts find that it does, and 800 courts find that it doesn't. In fact, there's about a half a dozen circuit courts at the federal appellate level, and they're all over the map since Bruen. The Third Circuit and Minnesota have struck bans just like this one by the Fifth Circuit Court of Appeals, saying that kids can own guns, while the 11th Circuit in Florida and the 10th Circuit have upheld the bans and said it was okay. This is going to go fast track to the United States Supreme Court. Could even be this year. Now, the Fifth Circuit's ruling is that under Bruen, the decision by Justice Alito, you have to find a twin for the regulation you're trying to apply today. So if you can't find it in old-timey times, that 18 to 20-year-olds are not allowed to own guns or have guns, then you can't apply it today. Again, not respectful of the modern realities of the firepower, the lethality that's on the streets today, and our epidemic of school shootings and mass casualty events. The fact that our school children have to learn at a very young age not how to duck under their desk to avoid an atomic bomb or attack like in the 50s or 60s during the Cold War, but what they should do at 2 and 3 and 4 and 5 years old when there is a mass casualty event or school shooting. And I lay that at the feet of the Republicans. They say it's a mental health issue, yet they cut funding for mental health. They say it's a parent issue, yet they cut government support for programs that strengthen the family. They say it's not a teenager issue. Well, then how do they explain the 70% of school shootings that are done under 18? I mean, even Justice Kennedy, when he was on the court and was dealing with other regulations, observed about the adolescent mind that it was immature, that adolescents, those 20 and under, 21 and under, right? As a proportion within society, commit more reckless crime, violent crime than any other group because of their not yet fully formed emotional state and brain. And yet Edith Jones and the Fifth Circuit thinks it's okay to put a handgun or any other weapon in their hands. Now, what was at stake was a 1968 Gun Control Act that made it a crime and just listen to this. I mean, this is such a minor regulation. The 1968 Gun Control Act didn't take weapons out of the hands of teenagers, nor did it find it that it declare it illegal for a teenager to have a weapon. It just made it so dealers, professional gun dealers, couldn't directly sell to a teenager a gun or an AK-47 or a semi-automatic that can be converted into automatic weapon or a semi-automatic that can be converted through a bump stock into an automatic lethality. So it's just that the dealer can't do it. The kid can still get the gun from friends and family. That was okay. And the kid's not prosecuted, nor is his parents for having a gun. You know, when you hear about parents being prosecuted, it's because of child endangerment laws, not because of gun control, that they allowed the gun cabinet to lie open. But technically, that kid did not violate a crime because he got his hands on a gun. So all that was at stake in this decision, and even that's not good enough for MAGA, is that professional dealers making profit, couldn't sell directly to a child. See, that's where the road divides among many roads that divide for Democrats, moderates, progressives, fair, free-thinking people, and MAGA, and the Republican Party. The road divides because we don't think it's a good thing that an immature American can grab a gun directly from a gun dealer, especially given the statistics that we know about. I defy anybody, put it in my comments, to tell me that in 1791, they had an epidemic of school shootings being perpetrated by under 21-year-olds. How many people were in schools? I mean, what was the student teacher ratio in 1791 in the colonies and in the States? What was it? 5 to 1, 3 to 1. These kids weren't coming in with muskets and shooting their teachers and their staff and their fellow students. It would take them too long anyway to reload. But now you have, with the pull of a trigger, you have 30, 40, 50, 60 bullets flying out. Some of them, I haven't even talked about ammunition and the technology of ammunition, armor-piercing bullets being used on human beings. Think about the damage that can happen there. But to Edith Jones, we couldn't find the twin or the analog in 1791. I mean, even John Roberts, they had to revisit the Bruen decision because the Supreme Court saw so much confusion that they had laid out about how to apply historical precedent to gun control laws. And some people might think, and this is why we do this show on Legal AF called Unprecedented, that once the Supreme Court makes a ruling about something like abortion, women's rights, immigration, immunity, or guns, for instance, that's it. There's no other cases on it. No. 1,600 trial courts have had to struggle with how to interpret and apply Bruen. It was so bad that just a year ago, Justice Roberts had to step back in with a new case we call Rahimi to declare, listen to this, that someone who has an injunction or a restraining order against them for having committed domestic violence, who is banned from owning a gun, doesn't have a right to have a gun with a domestic violence charge against them or with a restraining order against them. Now, people like us think, well, of course he shouldn't have a gun, but to MAGA and the Republicans, he should have a gun. Why should he lose his Second Amendment rights? Why should felons lose their voting rights? Why should Jan 6 people who stormed the Capitol, why should they be in prison? It's the upside down world of no rule of law. It's anarchy brought to you by the Republican Party and Donald Trump. So they had to step back in the Rahimi decision of the Supreme Court. And they had to say, well, courts aren't properly, blaming the courts, not their own opinion. Courts aren't properly applying our ruling. We didn't really mean there needs to be a historical twin, like identical, but if the regulation you're evaluating in 2025, for instance, has some sort of connectivity to an analog, something that you can analogize it to something in the 1791s, that's good enough for us. So they scraped around and they found Roberts because he wanted to uphold this ban. So he found something about domestic violence. But let's be frank, in 1791, women were considered chattel. They were owned by their husbands. They didn't have independent rights. They didn't vote. People could murder their wife and get away with it without going to prison. So, and black people worse. Black Americans are now slaves during 1791. So we had slaves. We had women as third-class citizens, owned as chattel, owned as property. Slaves owned as property. And this is the era we're going to use to apply gun control to today? I mean, when I tell people that the dead hand of history during a uncivilized, let's call it what it was, an uncivilized, primitive society in 1791, where guns were also primitive, we're going to have to look to them. They get to tell us how to control a modern day problem because the Second Amendment has taken precedent over all other amendments for the Republicans? How dare they? How dare they? And look at the landscape, the chaos that they've created. I mean, you got to give it up to the Republicans. They are the party of chaos. They're what do you call the first? How would you character? What is the one adjective you would use to explain the first 12 days of the Trump administration? With 10 lawsuits, 3 temporary restraining orders, tariff wars breaking out, the economy tanking, all in 12 days. What would you call that? I'll give you a hint. Starts with C and ends with chaos. It's chaos. They are the chaos party. Think about that when you think about who to vote for at every level of government when they have an R next to their name. I'm going to continue to follow what happens next with a split decision among at least 5 different appellate courts, meaning the Supreme Court's going to have to weigh in for the 3rd time since 2022 because they couldn't get it right the first time. Even Amy Coney Barrett, who's becoming as I've said before, is becoming the swing vote, meaning she votes more with the majority than any other justice. Even she questioned and scrunched up her nose about, we're going to use historical precedent from 1791 on gun control? Yeah, it was 6-3 and she eventually sided. But she has now suggested there are limits to the ability to use historical precedent as a guiding principle for the court. She'll be leading the charge in the oral argument about this next round of cases coming up out of this Fifth Circuit decision that I'm describing here. Follow it all here at the intersection of law and politics here on Legal AF. I'm Michael Popok. You can follow me on Legal AF, the podcast, on the Midas Touch Network, and on YouTube. You can follow me here on Legal AF, the channel, along with my other contributors that I curate. Hit the free subscribe button as we continue our drive for 500,000 in our first 6 months of existence. And I appreciate each and every one of you. Until my next reporting, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.